Hello, everyone, and welcome to Thursdays Live with Chug. Each week, we cover pressing topics that matter to you and your business. I'm Arianna Gonzalez with Chug Attorneys and CPAs, tuning in from our San Diego office. And joining me today is attorney Ishan Anand from our Herndon, Virginia office. Hi there, Ishan, and welcome.
Hi, thank you, Ariana. Thank you for having me.
So, for today's topic, we're going to be discussing marriage and family based immigration. Before we begin, just a quick disclaimer for those tuning in. We are live on YouTube, LinkedIn, and Facebook. This conversation is for informational purposes only. It does not create an attorney-client relationship. So if you have questions for us, please comment them below or send us an email anytime at info@chug.com. Let's get right into it, Ishan. Can you discuss the primary eligibility requirements for bringing a spouse to the United States through a marriage-based immigration?
Yeah, so the main requirement is the marriage. When you say spousal visa, meaning there has to be a legitimate marriage. And marriage should be recognized under US immigration laws. You can be a green card holder bringing in your spouse and children, or you can be a citizen bringing in your spouse. Sometimes your spouse is already in the US. So depends on different ways you can. If somebody's outside, then there are different processes, and if somebody's in the U.S., then it's a different process. Generally, what you need a legitimate marriage, meaning bona fide marriage. Then your sponsor needs to have financial ability to sponsor the petition, and then you go through the background check, medical examination that you don't have diseases, and then yes, there are two ways. One is consular processing. If you are outside, you go for an interview. If you are in the U.S., then you file adjustment of status. Depends in what status you are in. If there is no bar for you, you can adjust in the U.S. You can file a green card petition here.
That's really good to know. Thank you for touching on that. Can you talk about the difference between the K-1 Fiancé visa and the CR1 Spousal visa?
So, so K-1 basically, when we say fiance, it more or less is like you have intent to marry. So now you are a fiancé, but you intend to marry. So the petition you file, and then you say that the reason of entering the U.S. is to marry the U.S. citizen or a green card holder, basically. So when you say that, so you file a fiancé petition, and then within 90 days of entering the U.S., you have to get married to your spouse. Same if when you say CR, so it's conditional resident. If you're already married, so if you're already married, you file I-130 and you enter the country, and that's it. You enter as a conditional resident. Basically, if your marriage is less than 2 year old, then you get a conditional residency, meaning you have to go through the process again to remove the conditions from your green card.
I see. That's really good to know. So we're talking about the kind of evidence that people need to prove their marriage. So what kind of evidence is considered strong enough for the immigration officials to approve this?
Basically, bona fide marriage, right? That's what we need to prove, that the marriage is legitimate and bona fide. So bona fide marriage, the most important evidence or most important requirement, according to me, is commingling of funds. What USCIS is trying to see is that, do you trust your spouse with money? Joint bank accounts, joint traveling, joint credit cards, joint investments, um, insurances, lease. So all these things. So if you have all these things, photographs together, spending time traveling, all these documents go with your petition to show that the marriage is bona fide. Children, if you have children together.
Oh, that's really good to know. So we were talking about what defines a fiance. Is it simply just the intent to get married, and that's good enough for the immigration services? USCIS is okay with just the intention to get married, or do we need more information there?
So that you are not married yet. There was a ceremony, so and you were present there. So we have to show that there was a ceremony and the person, the sponsor, was present at the ceremony, and maybe religious, maybe they were like, maybe even if there are like 10 people there and they performed a religious some ceremony, then they will get married later on. That qualifies if you have pictures of that. So fiance is one step just before the marriage, and the intent is to marry. That's why you are seeking visa, and there's a timeline attached to it, because when you enter the country you have to get married. You need to have concrete plan that we will get married, and booking of venue. You have to buy, arrange maybe cards, so all those things.
That's really helpful. So I know a lot of people try to file for this on their own. So what are some common mistakes that you've seen applicants make when they apply for the K-1 visa?
So when they basically file on their own, most likely they don't know the basic requirements, that the documentation. They sometimes mess up. Also, the thing is, it's too premature to have proper documentation. Sometimes what I have seen is the person did not travel, did not go to the country where the spouse is, but just did it online, like like video conferencing type of thing. Then it's very difficult to prove that you were there, or it actually happened. Then you are trying to bring somebody from overseas saying that this person is my fiance. You never been there. So there are different things, and how will you prove? Because USCIS will not just say, okay, you want it, that's why we are approving the petition. You have to provide documentation. So proper documentation, they don't understand what the proper documentation is. Then many a times I've seen that they do not get married after coming to the US. They just don't do it. So there's a 90-day timeline, you have to do it. Sometimes because if you don't do it, sometimes they change spouses after coming to the US. And then you're barred then. If you come on fiancé visa and you don't marry that person, you cannot marry somebody else and file a green card. So it's tricky. So I would not recommend um, much about it. So you have to hire an attorney to do this.
Yes, thank you for stressing the importance of that. If you are thinking about going through this process, please make sure you're checking with your immigration attorney to make sure you have everything done correctly, because there are a lot of steps in the process. It is a complex process, and you want to make sure you get it right the first time. Thank you, Ishan. Can you talk about how having a child affects the process of filing an I-751 petition? And are there any specific waivers or provisions that need to be considered for dependents?
So 751, basically now we are talking about removing the conditions. So if your marriage is less than 2 years old, at the time of adjudication, there is also a misconception. I've seen many clients coming to me and saying that, yes, we are married, but we will file the petition, the I-130. We will file the family petition after 2 years. And I asked them the question, why? They say that somebody or some attorney said that if you file before 2 years, you will get a conditional green card, not a permanent one. So I want to clarify here, it's not the time of filing, it's a time of adjudication. So if you file it today, if your marriage is maybe 6 months old, and at the time of adjudication, if the petition is adjudicated after 2 years, maybe 2 year and 1 day, you will not get a conditional. You will get a permanent green card, 10 year. All right. Now, what we're talking about 751 is, suppose you have a conditional green card and you have a child with you. So, what you can do, you can file a 751 single application, single 751, include your child if the child entered the country with you within the 6 months period, or acquired conditional residency within the 6 months period when you acquired it. You can file one petition. Now comes to a question, if you say that the marriage is not there now, meaning maybe you are separated. You have a conditional green card, but you are separated, or maybe the sponsor filed for a divorce. Then what will happen? Well, in that case, you can file for a waiver, and the application is the same, 751. But what you have to prove is two things. Number one, the marriage was bona fide, that you did not just marry just to get papers. All right. Number two is life happened, meaning uh, it happened, the divorce or separation happened just like that, just like what normal people go through. Meaning you have to prove that the process was not planned. And if the waiver is not granted, you will suffer hardship. If you have a child, you can also include a child in your petition. Recently, I came across a case where the child turned 21. So, what happened? They filed for the green card. The family, meaning the beneficiary, had a child who received a green card, conditional one. Then the spouse, the sponsor, filed the 751 for both of them, child and the mother. But then after some time, when 751 was under processing, they filed for divorce. Now, what happened? The child turned 21. Now, what we have to do is file a waiver. Now, what to do? File a waiver, but the child is now 21, over 21. The child cannot be counted in the petition. However, uh, the process is that the child acquired green card already. So conditional green card is not like a green card with conditions. The green card is so conditional green card is a green card. You will be considered a green card holder, but there are some steps that you need to take after you acquire it. At a time of expiration, you have 90 days to file your application for removal of conditions. But it works as a green card. So this child now who is 21 is actually a green card holder, can apply for a waiver on its own. It's tricky, but it can be done.
That's really great information. Thank you for diving so deeply into that and even talking about a situation where you've had this case recently. I think that's really helpful for our audience. So we're talking about these visas, the fiancé visa and the spousal visa. How long does this process usually take to bring your spouse or fiancé to the States? Like from application
Historically,
to bringing them to the States.
understandable. So historically, fiance visa was faster. Now I don't see a point to do fiance visa. I say because now time frame is almost the same. It can go anywhere from 9 to 12 months to 18 months. We cannot, say with concrete. Um, Basically, we cannot say with certainty that how much time will it take. But generally, 9 to 18 months is the time frame, and it's for both. So now both the categories are taking similar time. So I don't see the point, because earlier what we used to do, because fiance visa was quicker, so we used to file fiance and bring the fiance, and then used to get married here, file for green card. Now I don't see a point, because both the things taking similar kind of time frame. If you are from Pakistan, more power to you, because Pakistan embassy, I'm seeing after approval in 2 years, still after completing everything, still waiting for the interview date.
Wow, that's really good to know that, now they have the same waiting time. So good to know. Thank you for that information. So you mentioned earlier that we have to prove financial ability to bring somebody to the States. So what are the financial requirements for sponsoring a relative, and how does one go about proving the financial ability? Can you touch on that a little bit?
So affidavit of support we have to submit when we submit application, meaning we will support the beneficiary until the beneficiary gets the citizenship. How we do that? We calculate the household members of the sponsor. and then we include the beneficiary into it. And then your household income should go over 125% of the poverty guidelines. This is the law. But let me go into numbers because you don't know how much is it, right? So general rule is what I consider is if you are a family of two, $25,000, and then when you add a member, add $7,000 on top, meaning at every additional member of your family or including the people you are sponsoring, add 7,000 over 25. That's gonna cover you.
That's good to know. That seems quite affordable for most people who are going through this process. So, what happens if your spouse or fiance has children? How does the immigration process work for them?
Very, very tricky. And recently somebody came to me and they said, we can file one petition for all of them. That is not correct. You have to, if you are a US citizen, you have to file multiple petitions, one for your spouse and individual petitions for your children. However, if you are a green card holder, you can file one petition for your spouse and include your children under 21, unmarried, into the petition. It's tricky because it's like it doesn't make sense that the citizen has to file multiple petitions, but a green card holder can file one, but that's the law.
That's helpful information. Thank you for sharing that with us. So, can you explain the adjustment of status process for a spouse or fiance once they're in the United States?
So once they are in the United States after the petition or before it, because see, if somebody is a fiance, that you cannot bring the fiance without filing a fiance petition and it's getting approved. So fiance, you file a petition, it's approved, go for interview, come to the US, within 90 days get married and file the adjustment of status. Adjustment of status is a green card petition. However, if you're talking about a spouse can already be in the US in some other visa, and assuming there is no immigration violations or criminal violations, overstays, everything is clear, you are not in J or not in removal proceedings, you can file I-130 and adjustment petition together. So if you are a citizen and you find someone, you can file I-130 and a green card petition together. If you are green card holder, it's not current right now. Historically, it was always current, but it's not current right now, but you can file it. Filing dates are current. The adjudication will not happen because it's backlot for green card holders right now.
That's really helpful to know. So, what happens if a marriage ends after the foreign spouse has arrived in the United States, but before they have obtained permanent residency here? What happens to their immigration status? Do they have to go back to their country?
So if the foreign spouse arrives to the US, the spouse arrives as a conditional green card holder. So conditional green card holder, when I say conditional, it has no conditions. It's a green card. Only condition is that after 2 years, between the 90-day period when the expiration is, when the card is expiring, within the 90 days period, you have to basically file a petition for removal of condition. Now you can do it in two ways. Either you can file, your spouse can file a joint petition that the marriage is still there, or you can file a waiver. However, in the case of death, it automatically changes to widower petition. So you don't have to do anything. So the petition that you file, suppose you have filed 751, right? Removal of conditions. If the death happens, so generally the I-130 turns into a widower petition. You don't have to do anything. They adjudicate I-130 as if it's a 360. I will not go into that details, but you can get it done. You don't have to file for a waiver because there is no separation of or divorce. It's just death.
That's good to know. How do recent overstays or visa violations by the foreign partner impact the marriage-based immigration process? Can you touch on that a little bit?
Depends on if your spouse is a green card holder or a US citizen. So if it's a US citizen and you entered legally and then overstayed, you are fine. You can file green card.
It's the foreign partner. If the foreign partner has overstays or visa violations, does that impact their immigration process?
I mean, the partner is a foreign partner, or if it's outside the country. So is the partner outside the country still? So you're talking about previous violations, or the partner is in the US?
I believe they're in the US, and if they have a recent overstay or a visa
Yeah.
violation, does it impact the marriage-based immigration process?
Yeah. So if the person, the beneficiary is in the US, married to a US citizen, entered legally,
Mhm.
overstayed, maybe also, worked illegally, you can file a green card. However, if you are a green card holder, then you cannot. You can only file I-130, and then you need a waiver. Once the waiver is granted, then you have to leave the country, go for consular processing, go for the interview, then you can come back with the green card. You
I
cannot
see.
get a green card inside the US.
Okay,
There are other ways, but we will not go into other areas of immigration law.
that makes sense. Thank you for touching on that. So, what are the legal remedies if a K-1 or marriage-based visa is denied? Is there anything the couple can do?
Yes, depends why it was denied. It was denied because of violations, criminal or overstay, um, or if it was denied because the marriage is not there anymore, or if it was denied because of because maybe your partner or your beneficiary went for interview and consular officer found out that the beneficiary had some affiliation with the criminal organization. Sometimes they see some tattoos on your body and they relate those tattoos to some different criminal organizations. Depends. And sometimes what I have seen is, um, because we have this mindset or tendency that marriage, if we are married, then US immigration law will consider the marriage. And that is true. US immigration law um, recognizes your marriage if your marriage was recognized in your country or your state, wherever it happened. But it does not recognize religious divorces, customary marriages, and religious marriages. US immigration law recognizes. However, if the divorce happens, US immigration law wants a decree in your presence in the court. Sometimes I have seen a denial happening because you got divorced through your customary ceremonies. In some religions, you can just simply divorce, like when some people accumulate and then they say you that's okay, just divorce, that's it. So, but U.S. immigration law needs to they want to see the decree, divorce decree. So it depends why the application is denied, and that's so basically the remedial action would be based on the reason for denial.
That's good to know. So it depends on a case by case basis. So if you are going through this, make sure you're checking with your immigration attorney so that they can help you out, figure out this process the best way possible so that, you don't get a second denial. So can you discuss with us what is consular processing and when is it necessary in the context of family and marriage-based visas?
Consular processing is when you are either not in the US or you are in the US but have some kind of violation. Maybe you overstayed, you entered illegally. All right, so then you need a waiver. And once the waiver is approved, then you have to basically leave the US, go to some other country, go to the consular officer for the interview, and they will adjudicate your application. And once, if they approve it, then you enter with a green card. So it's different. So one way to get a green card is consular processing, meaning outside the US by a consular office who is officer of the um, embassy. They give you they approve your uh, application, and then you enter with a green card. The other process is to be in the US and apply for a green card here. You don't have to leave the country.
That's good to know. So we do have a few live questions. I think we have time for a few of them, if that's okay with you. If
Yeah.
someone enters the US without authorization, but now has TPS, can they do an AOS via marriage? Is that possible?
So TPS is a status. So if you entered without inspection, I recommend when you have TPS, you travel. You file for your travel document, then you travel and then you enter legally, because that would count as your legal entry admission, and then you can file for your green card. Yes.
Good to know. Thank you for answering that question. Are you able to answer when will the F4 category visa bulletin move? Is that applicable to
When when would what?
when will the F4 category visa bulletin move?
Oh, even President Biden doesn't know. It's like we cannot comment on visa bulletin. I don't like to comment on visa bulletin because I have tried and I have said a lot of things about visa bulletin in the past. Everything went wrong. Nothing happens as per plan. You expect something, something else happens.
Good to know. Thank you. I figured that would be the case. Thank you guys, everyone, for your questions. We are out of time. This does bring us to the end of our conversation. If you still have questions, please email us anytime at info@trug.com and we'll connect you with Ishan so he can help you out. And thank you so much for joining us today. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. And if this video was helpful, please make sure to give it a like and turn on the notification bell so you can be notified of our next upload. If you have any questions or suggestions, email us anytime at info@trug.com. And make sure you join us back here next week for more topics that truly matter to you and your business. Until next time, stay safe and take care, everyone. Thank you for your questions. And thank you, Ishan, for taking the time to give your insights on all of this. I know you're very busy, so thank you again.
Thank you.
Thank